Thank you very much for coming. We've got quite a lot to do today. The GDPR section is part of our 3-hour presentation, so obviously it's quite condensed, but we think we've hit most of the main parts of it. My name is Robert Linford, as Bryony said. I'm Head of Practice at Transition Law, and we've called this short webinar the Coronavirus Business Triple Threat. Threat 1 is data protection, getting that right. Threat 2 is business protection, to look after the business if you can't. And threat 3 is personal protection, should the worst happen to the business owner. Now, threat 1, then we'll start with that. That's the longest one. Business owners, we say, need to avoid the GDPR landmines. And really, there's 4 big things that you need to do. So become better educated in compliance issues for yourself, which means you can then cascade that information onto your staff. Check your suppliers and subcontractors' compliance, which is not something everybody knows they have to do. There's a legal requirement for that. And of course, once you are compliant, tell people about it. That way you can get more business. People like to work with compliant firms because they feel safe handing over their data. So that gets you ahead of the game. Unfortunately, many people are like Catherine Tate schoolgirl. There she is. And when you talk about GDPR, they tend to say, I'm not bothered. And we try and explain that it is an important thing, and they reply, I'm not bothered. Well, we like to give you some real and serious reasons to bother about GDPR and data protection generally. The first is that you can get fined. All of these things are offences, and you can be fined by the regulator, some of them in a more serious way by the courts. You can go to jail. We've had 3 now jail sentences as a result of data protection issues. You can have your business taken away, and as a fledgling business, it's very important to make sure you get good foundations, and you don't want any immediate problems, obviously. And in a more serious cases, they will disqualify you as a director. So even if this business has now failed, they stop you from going on and starting another. So there are some fairly serious things about this, although for the rest of it, we'll try and keep it fairly light. And the big one, of course, is that the ICO, the regulator, the Information Commissioner's Office, everything they do goes on their website. So if you do get a fine, or even if you get a warning, that will go onto their website, and you're there named and shamed, and that tends to stay there for quite a long time. And then the final big reason to do something, it is actually the law. So we'll start the presentation properly with which laws we're talking about. So the first one is the European General Data Protection Regulations, universally known as GDPR. All of that was put into our own UK legislation, the Data Protection Act of 2018, when it came in. And then we've got the Privacy and Electronic Communications Regulations. This relates a lot to marketing, so it's very relevant for small businesses. These regulations came in 2003, so they're not new, but it's still the case that most people tend not to understand them. And then finally, the e-privacy regulation. There's a new version supposed to have already come out. I doubt very much whether it will come out now before we finally resolve the Brexit question. Okay, so there's things as a business owner that you're going to hear from people that you're dealing with, from prospects, from clients, and from suppliers. They're going to be asking you whether or not you're GDPR compliant. Now, some of your suppliers and some of the people that you want to do work for have a legal requirement themselves to check as to whether you're compliant. Large firms, councils, they already know. If you want to tender for work with a council anywhere in the country now, they will send you quite a detailed questionnaire to prove that you are in fact compliant. And what they're really saying is this: they need you to make them feel safe about letting you work with them. And that's really what it's all about. So what can you do to make me feel better about recommending you, appointing you, giving you the tender, etc. And as an example, if you go to a bank and the bank lends you a whole load of money today, and then doesn't bother to check that you're compliant. Actually, some banks are still not checking, but most of them do. So they lend you 20,000 today, and the regulator finds you 100,000 tomorrow. Probably somebody's head will roll, and so they're protecting themselves by asking the question. Now, this is an introductory session for GDPR, so we're going to go right back to basics and start with some definitions. So before you begin to do anything at all with regards to GDPR, data protection and so on, you need to ask yourself this question: am I the data controller, or am I the data processor? Now, for most Businesses, you're going to be the data controller. But this data controller data processor relationship is a key component to compliance. First of all, your staff, if you have any, are always going to be data processors. You've got a written contract with them already, and it should have been updated for the GDPR additions that came in 28. Now, any third-party company you use is also your data processor. If you engage a courier service, for example, or your accountant, or you engage a webmaster to build your website, all data processors working on your behalf. Suppliers as well, anybody who you exchange personal data with. I always make the point that if you go into a shop and you buy something over the counter and you walk out and you don't give them any data, then obviously it's not really an issue. But if it's somebody that you're exchanging data with, your accountant's a good example. You, at the end of the month or even the week, you'll send your accountant data about your staff, about your business, and other people connected to it. So they're acting as data processors. You must have a written contract with every data processor that you have. Now, we all understand that staff have staff contracts, but within that must be, there's 10 actually, the 10 components of a data processor's contract. The contract has to be in writing, that's what the regulations say, and they even lay out in the regulations what the terms are that must be contained. So that's the basis of it. Are you the data controller? Are you the data processor? As a business owner, you'll be the data controller, but you're working all over the place with data processors. So more definitions then. What's personal data? We keep talking about personal data. What is it? In a nutshell, it is information that identifies a person. And anything that identifies a real person has to be a living real person, not a company or something like that. But it can be a name or an address. It can be an email address. It can be their face on your CCTV system. Anything that identifies them is personal data. And consequently, the definition is very wide, and it applies both to automated personal data, such as being collected on a CCTV system, and manual filing systems. People often forget about the manual side of it. So paper records do count. Not every bit of paper in the office, but if it's a filing system, something where you need to go back to it and find things in order, then it counts for GDPR. And obviously, the easiest one to think of for that is a diary. A diary's got pages all marked up, so you know exactly where to go to it. That constitutes a personal data manual filing system. So that's the basic data, and then we go up a level. If we're dealing with sensitive personal data, what we call special category data, then you have to take even more care. Special categories would include information about somebody's race, medical history, sexual preferences, staff. All staff data is special category data. Biometric stuff, so if you have the fingerprint readers when you go into work to check your hours, that's special category data. Criminal convictions and offences aren't included in that, but there are some safeguards about those. If you're processing criminal convictions, it's a fairly niche market, but if you are, that's all taken account of in the end. So processing, we've talked about personal data, and we'll keep talking about processing personal data. What is processing? Well, in a nutshell, processing is anything you do to it. That's really what it comes down to. It's extremely widely defined on purpose to encompass everything that you do. So here's some examples: collection of information, recording, organizing, storing, and even as far as destroying it. So if you get a whole bunch of records that you've been keeping for a long time and you get them shredded or burnt or whatever it might be, that destruction is in fact processing personal data. Now, there's a lot of stuff to remember here, but we've narrowed it all down to 3 basic things that you have to do. The first one is all businesses, all commercial operations have to have a registration with the regulator, unless they're exempt. There are some exemptions, but most businesses have to register. The registration is split into 3. So we've got tier 1, 2, and 3, and it all depends on the size of the business we're talking about. So if you've got 10 staff and up to 632,000 turnover, which covers most small businesses, you're at tier 1. That will cost you just £40 a year, or £35 if you put it on direct debit. Now, we recommend that you put it on direct debit for 2 reasons. First of all, it's cheaper. That's always good. But the second thing is you won't forget to renew it next year. And the fine for forgetting, even if it's only a few days, is 10 times what you should have paid. So a £40 registration will cost you £400 in the fine, plus of course the £40 that you have to pay for this year's registration as well. That's the first thing to do. The second thing to do is a data audit. This is immensely important. I must make the point, whether or not you need to register, even if you're exempt from registration, you have to do a data audit, sometimes called an information audit. And the data audit is where you basically sit down and gather together an understanding of where all the data that your business deals with comes from. A bit like a flow chart. So where it comes from, where you get it from, how you look after it, how you deal with it, what the rules are about the reason you can have it. That's the 6 lawful bases. And eventually how and when it will leave the business. So it's a bit like a flow chart. Then you take the information that you've got from the data audit and you prepare a handbook of policies and procedures based on it. This is the most difficult part for most folks because they understand what the business is all about, but it's a bit too easy to look online and copy and paste somebody else's. But this handbook of policies has to be bespoke to your business. In there's a whole bunch of policies. We have about 20, up to about 20 different policies, but the ones that you'll always come in are the subject access response policy, which we're going to talk about in a minute, a data breach policy, a data retention policy, staff if you've got them, and of course CCTV if you have CCTV. As a quick aside on CCTV, if you work from home, there isn't any law now about CCTV at home being registered. So that's something that GDPR did give us, which was a bonus.
Oh, but just a quick question.
Yes, please.
Same for sole traders, presume the ICO registration.
Yes, it is. I mean, it's for any commercial operation. We did a project last year with the Avon Corporation. Everyone knows about the Avon lady, and each and every one of them have to have a registration.
Thank you.
I usually get silence when I say that. Okay, so we'll move on to the data audit. A data audit, as I say, is basically a sit down. It's a formal thing, but it's where you figure out where the personal data under your control comes from. And I can't stress enough, it has to be bespoke to your business. One of the things that the regulator will probably do if you do get any contact with them is they'll ask you the date of your data audit, because that's a quick way for them to find out whether you've actually done what you're supposed to do. It says there on the screen, it's a key document and it will form part of your defence in any prosecution. So it's very important, you've got to keep it. You've got to write it down and you date it. That's very important because then you can demonstrate A, that you've done it, and B, that you kept it. And it's got to be bespoke, as I say, to your business. You create them following the 7 data protection principles and applying the 6 lawful bases. I keep talking about lawful bases, I'm going to lay them out for you. So here we go. 6 lawful bases, Article 6 of the GDPR. What that says in simple terms is every single piece of data that you have, you've got to have a legal reason for having it and processing it in your business. And it has to fit under one of these 6. So the words are fairly straightforward. Consent, if somebody, say, fills in a notification box on your website and sends you a query, they've sent you their data by consent. So you can phone them back up and find out, what the questions are and so on. Contract is another one, and that means we make contracts all the time. When you sell some goods or you sell some services, you've made a contract with the person, and the rules about contracts, and they're different from consent. Legal obligation simply means that you're required in law to process the data. A good example of that would be if you have staff and you're required in law to tell HMRC about their pay-as-you-earn and hours and the amounts of money they've earned. That's your legal obligation. So your reason for processing the data comes under C. Vital interests is kind of an interesting one in as much as that's processing to save life. The best example I've got there is if you worked in the care industry, very important at the moment, and you happen to know that somebody was allergic to penicillin, for example. You couldn't tell people that, that's restricted information. But one day, if they were in trouble and the ambulance man was about to stick some penicillin into them, you could speak up and stop him doing it. That's processing to save life. That's vital interest, not something you're going to come across all the time. Public task is for public bodies. So when the council creates a voters list and various other things that they do, that's all coming under public task. We're going to talk about the very latest information from the ICO that came out the day before yesterday towards the end of the presentation, and public task features in that. And finally, legitimate interest. This is the one everybody gets confused about because they think it's a cover-all that just covers everything, and it really isn't. But the NB there says LIAT, which is legitimate interest assessment test. You cannot use legitimate interests to process data unless before you do so, you have a written legitimate interest assessment test, which is a proper document that you filled out to explain why you're using that method. The best example of that is CCTV, because it doesn't come under any of the others. You can't do CCTV by consent, that would be silly. You can't do it by contract, otherwise you'd probably run out of paper. So legitimate interest is the correct one for CCTV, but you must have the document that says the assessment test that says you've sat down and worked out the legal reasons why you can use it. Okay, we're going quite quickly, folks. I understand that. Please ask questions as we go if you want to, and Brian will pass them on. Now, the area that most small businesses encounter data protection issues is with subject access requests. And it's very important that you understand this, as there isn't a lot of time here today, but the basic idea is this. If you're in business, everybody, whether you know them or not, has the absolute legal right now to know whether or not you're processing information about them. So they can send you a request. They're the data subject, and these are data subject access requests, or SARs that we call them. So anyone can make this inquiry. You don't have to have done business with them. You don't even have to know them, and there's no set format. So they can come in verbally, they can come in by text or email or letter. If they are verbal, you need to get them to confirm it. And you have to respond. You can't ignore it. If you do ignore it, they'll report you to the regulator. So you have to respond within a month. There's a new European Court of Justice case to define what a month is. And it says there it was determined that if the receipt day is day 1 is the 3rd of September, the 3rd of October is the month. You wouldn't have thought we'd have needed the case about that, but there you go. So it's not working days, it's one straight month, and that's the period of time that you've got to respond. You have to do it without charging the inquirer. Pre-GDPR, these things existed, but when you sent them in, you had to send £10 to the company for their effort and admin, but that's all gone. So needless to say, A, we've got a lot more of them, and B, it's a bit more of a nuisance because the rules have changed. So you have to do it for free. You have to use an appropriate format, which is only really a formal way of saying you can't, write it in Sanskrit or something. Most people just reply by email. That makes it simple. And you mustn't alter the data before sending it. I'm smiling because we've just had a case about this just a few weeks before the lockdown started. There was a lady responding to an SAR, and she thought that some of the data was a bit incriminating, so she took it out before she responded to it. Well, she got prosecuted and fined, and that is one of the rules. You must send whatever data you've got as it is. Now, that's a lot to do, but there is a bit of protection for the business. And the protection is this: when somebody sends you a subject access request, you need to make sure it's really them. And in the law, it says that you can make them identify themselves to you. If there's any doubt or you suspect fraud, then you must check that it's actually that person. Now, you cannot usually ask for more information about them than you're already holding, but there have been some cases where people have sent in a subject access request in somebody else's name to catch the business out. It's a little bit of a trap. So this identification thing you must take seriously and remember to do it. Never ever respond verbally, that's one thing. And before you do respond, just make sure it's absolutely the right person, because if you send somebody's data to the wrong person, of course that's a data breach and you're in trouble for that. So these are the reasons to identify them, protect you, and if they fail to identify themselves, don't respond. It's as simple as that. You should keep a book, small book. We have one in the office here, just a little hardback book like that, where you keep any inquiries. You just write them in, and if they fail to identify themselves, you write that in as well, because in a month's time, when you haven't responded, they may decide to report you to the regulator, and the little book will protect you and prove that you haven't ignored it, you've actually followed the correct procedure. So there we go. Protect yourself on paper is always a good idea. You also must record any subject access requests. So even if you do respond to them, make a note of that as well, and its outcome. So, Billy Smith sent me the subject access request. We checked his data, checked it was him. We replied on this date. And so if he goes to the regulator to complain about you, then you've got some evidence that you've in fact done the job. So that's subject access request. And don't forget, anybody can send you one. That's the important thing. So effectively, anybody in the country. Theoretically, I suppose anybody in the world. Right, moving on to the dreaded data breach. Now, we understand about data breaches, I'm sure. We don't want data breaches. The little explanatory thing that I came up with was, if you understand what the gardeners say about weeds, then that's a good analogy for data breaches. Gardeners say that a weed isn't a bad thing, it's just a plant that's in the wrong place. And we will tell you that a data breach is where you've got data in the wrong place. Somebody who shouldn't be able to access it has done so. Somebody who isn't allowed to look at it has done so. It can be a deliberate act from somebody outside hacking the computers or whatever, or indeed somebody stealing files and that kind of thing. So data is where it's not supposed to be, and you've had a data breach. Now, if that happens, what you need to do is you need to assess the risk to people's rights and freedoms as a result of the data breach. And if you decide that there is a risk, then you need to report that to the regulator. And you've got 72 hours in which to do that. However, if we change one word and we say that there is a high risk to people's rights and freedoms, then not only do you have to report to the regulator, but you also have to tell each individual whose data has been breached. And the classic example of that would be where you've lost a whole bunch of credit card numbers. Now, most firms don't keep them anymore, which is brilliant. Most of us use things like PayPal and Stripe and all these businesses who will do all the payment transaction for you. But there are still organizations where you can telephone and somebody will write your credit card number down over the phone. And who knows if that bit of paper is destroyed or dealt with incorrectly. So there's potential for a high risk to your rights and freedoms. Obviously, if your credit card number goes astray, that's a high risk. So you have to tell all the individuals involved in a high risk breach, as well as reporting to the regulator. Now, the 72 hours thing is an interesting thing in as much as for slightly bigger companies where there's a lot of people involved, the communication has to be good, because if a breach happens on Friday, by the time somebody gets around to mentioning it on Monday afternoon, your 72 hours might have run out. So it's very important that the staff training side of it comes in and people understand what to do about it. So there we go. Oh yes, of course. Now the ICO tell us that when this came in, they were massively overwhelmed by people reporting breaches they didn't need to report, just in case. So don't do that. Please understand it's a couple of simple rules: risk to the rights and freedoms, higher risk to the rights and freedoms. If you need to make a report, do so. If you don't, going back to my little book, there it is. If you have a data breach that you don't report, just write it down in the book that you've done it, you've decided not to report it, and that at least gives you something to cover if anybody comes back with some queries about it later on. So there you go. If you decide not to report the breach, that's fine. It's your decision, but do document the fact that you've chosen to do that. Now, so keep a record of all data breaches, regardless of whether you report them or not. Okay, folks, now I'm rattling through this, I'm afraid. We're covering a lot of ground, and there is a sheet that goes out at the end, so we can catch up on some bits and pieces. And we do have a free advice line as well, people can ring for particular help. Keeping half an eye on the time so I don't overrun. Now, the breaking news is that, surprise, surprise, we've had the coronavirus for a few weeks, and the regulator has put now 2 guidance updates out. The latest one I'm going to précis for you here, and then the day before yesterday they talked about people going back to work. That's very important, so we're going to cover that one as well. So basically what the guidance is that they will allow a little bit of flexibility and leeway with some of these timescales that we've been talking about. But, and it's a big but, all of their guidance presupposes that your business is already compliant, that from day one you're actually doing things correctly. If you're doing things correctly, but because of coronavirus, you've got people working from home, that kind of thing, things are slowed down, and maybe things take a bit longer to finish up with, that's okay. But there's no quarter given for not being compliant in the first place. They certainly haven't given any leeway for that. So you all still have to do the 3 things we talked They have created a data protection and coronavirus hub, which is right on the front page of their website. I'll give you the website details in a sec. If you go there, there's a whole bunch of advice about what to do regarding the coronavirus. But as I say, be wary if you're coming to it new, because if you're in business and you're not compliant, although the regulation, the new stuff will apply to you, it will assume that you are fully compliant in the first place. That's the thing to watch. So, assuming that you're compliant, the ICO will now be concentrating on these things. They will accept slower response time. So if you've got a subject access request, and you've got to prove this, but if because of distribution of the staff and so on, it's taken you a bit longer than normal to get the information out, they'll kind of put up with that as long as you're trying to do the right thing. They themselves will be concentrating on the larger public issues. Now, this new NHSX app that was trialled on the Isle of Wight, I think it was last week, wasn't it? That's a really interesting data issue because in order to operate the app, you've got to give the government your personal data, and the regulator is monitoring that quite closely, because if they're planning to roll it out right across the country, which I think they are, that's going to potentially have some big data protection repercussions. But what they have said is that they are still there, they're still working, and they will definitely come down hard on organisations that intend to exploit the virus. For example, we've seen a huge increase across the board in all kinds of different scams online and phone calls, and even people turning up at doors apparently pretending to be NHS staff and conning people. So if any businesses involved in that kind of thing, nuisance calling, etc., they're going to come down on that. So they're basically maintaining their position there as the regulator. And they've also said that they will assist with recovery advice once the crisis has passed, which will be. Now, they have also issued advice. This is the day before yesterday, so this is literally brand new. They have issued some advice to employers regarding testing workers that are returning to work. So we bring the next slide up. And this is what it says. If you go onto their website, there it is, ico.org.uk, and if you put in workplace testing guidance, you'll get all this information that I'm just about to post. There's a bit more than we've got time to go through. But first of all, if you're testing workers for COVID when they come back to work, that's going to be okay, but it of course is medical. If you're testing somebody's blood or you're doing temperature cameras, that's medical information, and that means it's special category data. So immediately you're into higher protection. Councils and public bodies can use the lawful basis of public task. Now we quickly went through the lawful basis earlier. Public task is only available for the councils and public bodies. I think maybe the university might get away with that, but certainly individual private businesses can't use that. So what they have to use is legitimate interest, which means, as I said before, you have to do a legitimate interest assessment test before you process the data. So if anybody who's listening here has got staff who they're planning to do testing with, you've got to have your assessment test written, and, as we'll see in a minute, a DPIA done before you start the testing. You can't do it afterwards. That's not allowed. There is within the GDPR what's called the accountability principle, and the regulator says that they will be expecting people to consider doing a data processing impact assessment, which is another document which looks at whether or not what you're about to do is going to be a good thing or not, and follow the rules and so on. Now, you don't have to do that. It's only advice. But as always, if you decide to go against the advice of the regulator, please have some kind of written document justifying the reason why you decided not to follow their advice. Because if you haven't done it because you can't be bothered, then that's not going to fly well if something goes wrong. As always, if you're collecting data, it needs to be adequate, relevant, and only limited to what is necessary. So if you're collecting, for example, if you have thermal cameras, that's one of the new things that's coming out, and you decide to ask all your employees for an entire medical history of all their cousins and everything, that's not going to be limited to what's necessary. So don't do that. All records, all GDPR records, and especially special category data must be kept securely. So if you wind up with a list of employees who have tested positive, that isn't something that must be lying about on a desk that anybody can see. That's very Keep your staff informed though. The transparency principle is very important, but there are some specific things that are going to come because of this. So people are going to want to know if you're sitting next to somebody, even with some kind of social distancing. They're probably, you know, together if they go to the water jug or go to the loo or something. You need to know, or you'd like to know rather, if your colleague is positive tested. Now, that there are rules about this and what you can tell and who you can tell, and that's part of the advice that's being given. Staff will also volunteer information to you, and you must protect that information at the same level. That's special category data too. If somebody says, oh, I've had this disease, or I've had it, or I haven't had it even, that would all be special category medical data. As a general rule, staff are entitled to send their boss, their employer, a subject access request, as we spoke about before. What that means is that this is also covered by these regulations, so you need to be ready for that. And then finally on this one, the SCC and the ICO have set a new set of guidelines up for CCTV, especially with thermal cameras. The thermal cameras are great. I think they seem to work. They use them at the airports, and they can immediately see somebody who's obviously a lot warmer than somebody else. The SCC, by the way, is the Surveillance Camera Commissioner, just in case. So that's the very latest from the regulator. I've got half an eye on the clock, folks, because we're about to now. So that's threat one. We said 3 threats, and that was going to be the longest. I haven't got another 30 minutes to do on each of the others. Just a quick run through. But a quick review of threat one is this. All commercial enterprises must register with the regulator on that email address, on that web address, unless they're exempt. They must complete and record a data audit bespoke to the business, and then from that write a handbook of policies and procedures. But there are other things to think about. You've got to think about marketing. Almost all of the small business prosecutions are around marketing errors. You know, contacting people that you're not supposed to contact. Third-party compliance checks. You've got a legal responsibility under Article 28 to check your suppliers. But what we are going to see, and the government announced in the last couple of days, is that they're going to have health and safety inspectors coming around checking businesses to see if they're doing the distancing once the workers get back to work. Now, I know for a fact the HSE haven't got enough inspectors to go around themselves. They would take far too many. So they're probably going to have independent private health and safety people being sent around to do it. Now, they're coming to take data from you. So before you give them any data, first thing I would be saying, if anybody turns up at my business premises, is to check that they are GDPR compliant themselves. Because if they're not, you're in breach by giving them data. So that's going to be very important. Staff training is a legal requirement, and then demonstrating compliance to others to increase your business. Once you are compliant, tell everybody about it. We have a system you'll see in the top right hand side of each of these slides called Shield. It's completely free of charge. If you are compliant, then you can have Shield membership, and it's something you can use on your website and your paperwork to show people that you are a compliant. So there we go. And we also have, just to wrap this one up, we have a 30-minute legal advice hotline, which you can ring up and speak to one of the lawyers, or myself, and that's the number there for it. And that's completely free, and you can check if you're not sure. You can do a quick check with you and see whether or not you need to do any additional work, and we'll write all that down and email you a report about it. So there we go. So that's threat one for GDPR and data protection. Threat two is business protection. Now, you may or may not have come across these. It's quite important, especially with the situation we've got with the coronavirus. If you get a bad version of it, I understand most versions are quite mild, but if you get a bad version of it and you wind up in hospital or even in an ICU, just like the Prime Minister did, so it's no respect for persons, who's going to run your business? And you, in order to legally do something for somebody else, you have to have what's called a power of attorney. So a power of attorney is the legal right to act for another person. There's two people, the donor and the attorney. The donor is the person giving the authority. The attorney is the person who is doing the job. Classic example of an ordinary or general power of attorney is if years ago, if your parents had the pensions paid out at the post office on a Thursday afternoon or whatever it was, they would often, when they couldn't walk down to the post office any longer, ask their son or daughter to go and get it for them. And a power of attorney was a piece of paper that they signed in order to allow you to do that. But if they lost their mental capacity, then the general power of attorney stops with it. In order to have the authority after somebody loses their mental capacity, then you need what's called a lasting power of attorney. It does exactly what it says on the tin. It lasts or survives the donor's loss of capacity. And then they can carry on acting for you. But of course, with these, you must give the authority before you lose your mental capacity. Once you've lost it, then it's too late. Now, losing mental capacity doesn't mean necessarily old age. It doesn't necessarily mean dementia. You can have an accident on the road and bang your head and wind up in a coma at any time or any age. And of course, with COVID and the coronavirus, then that can incapacitate you for a short or a long period of time. Things to think about with these are who would be able to run your business if you were in a coma or you spent a month in ITU. Can they access your business bank account? Because the chances are, if it's your husband or wife, they can't. Can they pay wages? Can they negotiate with clients? Can they buy and sell on behalf of the business? If not, the business might grind to a halt. And an LPA, a lasting power of attorney, can solve all these problems, but only if it's prepared and signed before the person is unable to act. So just quickly, there's two types of LPAs, one for finance matters and one for health and welfare matters. The finance one is usually all you need for business, but you can have them in your personal life as well. One of the sort of weird things about the way the British law works is if you lose your mental capacity and you haven't got an LPA in place, the chances are the Court of Protection will send around an accountant to figure out your financial matters and somebody from social services to work out whether or not you need to be in a nursing home, and your husband or wife has no say in the matter. So if you want them to have a say in the matter, you need to get a lasting power of attorney in place prior to losing your capacity. Business LPAs, of course, show a high degree of foresight and understanding, and it supports and protects the business, your staff and your business partners. A good quality partnership agreement can do a similar thing, but most people don't write one. And the Memorandum and Articles of Association of Limited Companies can do the same thing, but once again, most people get an off-the-shelf company and don't bother changing the name. So the only other way to do it is with an LPA. We have the estate planning team here at Transition Law. They will give you free advice on that if you want some more information. And it's really weird getting no feedback from the team. I can't see anybody out there. I'll finish this one with a bet 3 and have a quick run through wills and probate matters. We've got about 3 minutes. So things to know about wills. About 60% of people in the UK never get around to making a will. Some won't even talk about it. Some think they'll live forever. It's quite a weird situation. On the continent, they're extremely good about making wills, weirdly. But if you buy a property on the continent, there's almost always a will there waiting for you. So more people just do it because, it all happens. The UK has a deal with its citizens. It's quite simple. In the UK, you can pretty much do whatever you like with your stuff, your money, your possessions, your business, etc. when you die, providing you make a will. There are a few exemptions and things you can't do, but generally you can do what you like. But you've got to make a will to do it. If you don't make a will, you die intestate, as we say, then the government tells you what happens to your stuff. And the intestacy rules, some of them date back about 100 years. So it's a bit unlikely that they'll do what you think they'll do. So what I'm going to do now to wrap this up is do you some snippets of wills and probate law that most people aren't familiar with, which is usually important. So if you own a business and you have a will, you need a business clause in your will. If you either haven't got a will or you've got a will without a business clause, the chances are all your executors will be able to do is close the business down. And that might not be at the most financially beneficial time. So for example, right now, with the coronavirus, closing a business down and trying to sell it or sell its assets would probably be a nightmare. If you can wait another 12 months, then things will probably have improved and things will be a lot better. But they can't wait 12 months and not allowed to unless there's a clause in the will that gives them that authority. You can't guarantee to leave shares or ownership of a business to anyone unless you have a will. That's just a simple fact. Some people believe if you're married, then your spouse will inherit everything. We hear all the time, oh, I'm not going to bother, my wife will get everything. No, she absolutely will not. It doesn't work like that. Many people believe it does, and it absolutely doesn't. If you're not married, if you're cohabiting in your house, so you're living with somebody, but it's your house, they will not inherit the house automatically without a will. And they may well be thrown out of it by members of your family who probably will inherit when you didn't want them to. Other things, you can't leave a gift to any charity or a friend or indeed anybody without a will, because if you haven't got a will, the law says the way in which your stuff is distributed, and you can't. You can't protect your children against your spouse's remarriage. This is hugely important. If you die and you are married and your spouse remarries later on, if you haven't left what you want to happen with your children in the will, there's no protection for them, and many children lose out on that basis. Minor children are another issue. Children under 18. Let's imagine that two married people die in a car accident together and they've got a couple of young children back at home, then they imagine that the kids will go to grandparents or aunties and uncles or whatever it might be. They will not, unless those aunties and uncles and grandparents have been checked out by social services, and that can take a while. And the children who have just lost the parents might have to go into care until it's all sorted out. It's really an unpleasant situation, and you can avoid the whole thing just by making a will. Few points about houses that people tend not to know. If you own a house or other property with another person, you might have nothing to leave, because it depends how you own it. We own things in two ways in the UK. We have a joint tenancy and a tenancy in common. If you're a joint tenant, the moment you die, the other person inherits the lot. So if you're thinking that you've got half a house to leave, that might not be the case. So that's the same. A trust in the will can save you all sorts of time and money. And it can achieve objectives, but you can't have a trust in a will, obviously, unless you've got a will. Disabled children, disabled spouses come to that, but disabled children can be protected by a will. If you suddenly leave a disabled child a whole bunch of money and they're getting certain benefits, that might, the money that you've left them might overcome the limits for the benefits, so they lose the benefit, and then getting the benefits back once they've spent the money might be impossible to do. And finally, if you do own a house, you'll probably these days be subject to nursing home fees if you go into care, and professional estate planning can help with that. It's not a simple area, and please don't imagine that if you sell your house for a couple of pounds to your son or daughter, and they theoretically own the house, that'll avoid nursing home fees. That definitely doesn't work. They're all over that one. Very good. Anyway, so some good news to wrap up with. We've had to do this a lot of bullet points and we've covered quite a lot of ground. I hope it's been useful, but every single example I've just given you can be overcome by making a will. And we always say this: if you need to have a will, if you've got a business, a property, a partner, or a child. So there we go. And of course, the estate planning team here again can give you some free initial advice about that, which is always a good way. At least, please find out where you stand with